Good afternoon, everyone. I'm Professor Deborah Healy, a Director of the Herbert Smith Freehills China International Business and Economic Law Centre, and I'm delighted to welcome you to this online panel where we'll discuss what do economic sanctions mean for business. I begin today by acknowledging the traditional custodians of the lands on which we meet, the Bedegal and Gadigal people, which is where UNSW stands, and I pay my respects to the elders past and present. I would also like to extend that respect to other Aboriginal and Torres Strait Islanders who are here today. The US, UK, Australia and many other governments have imposed sanctions on Russia following its invasion of Ukraine. The sanctions penalise President Putin, leading officials and their family members and others who have benefited from the regime. There are many strands to the sanctions, but they include economic measures to ban new investment in Russia, severe sanctions on the central bank, Alpha Bank and Sberbank, SOEs, bans on the export of military and other goods, including luxury goods, and I read today they're looking at Russian imports of Russian coal. This seminar will provide you with practical information about the implications of the sanctions for business locally and globally, and how the challenges might be addressed. We will also focus on the global implications of these sanctions for business and more generally over the longer term. To do this, we've assembled a diverse group of speakers. We're delighted to have four panellists to discuss a series of questions and topics on the question from different perspectives for about 65 minutes before we open up for questions. So, at the outset, I'll introduce our panellists. Our first panellist is Ms. Jackie Wootton, who's a partner at Herbert Smith Freehills and co-head of the firm's Australian corporate crime and investigation practice. She advises on disputes, investigations and corporate crime, and she holds particular expertise in anti-corruption sanctions and compliance, and frequently engages with clients on multi-jurisdictional matters of high reputational significance, including in countries across Asia, the UK, the US, the Middle East and Africa. She has won a number of awards and she works with clients by both advising on contentious matters and implementing compliance frameworks that are often focused on anti-bribery and sanctions policy. So she brings to clients globally informed experience in the areas of anti-corruption, trade sanctions, ESG, business and human rights, modern slavery and whistleblowing. Our second panellist is Dr. Jonathan Boniccia. Jonathan is a senior lecturer at the Faculty of Law and Justice and is best known for his research on investment treaties. He also considers the interrelationships between different systems of foreign investment governance, including investor-state contracts, national investment laws, national investment dispute management agencies and international principles. And from 2022 to 2025, Jonathan will be a chief investigator on the ARC funded project China's Belt and Road Initiative, a new model of economic governance, along with other CBIL colleagues. The next panellist is Associate Professor Weiwon Zhu. Weiwon is Associate Professor at the Faculty of Law and Justice. He's published widely in the field of international economic law, particularly on the nexus between international trade and China. He's currently co-secretary of the Society of International Economic Law, SEAL, and editorial board member of the Journal of International Trade Law and Policy. He consults for governments and major companies on trade remedy cases and other cross-border trade and investment matters. And our final speaker is Professor Heng Wang. Heng is a professor at UNSW Law and Justice and a director of the CBIL Centre. He explores the future of international economic relationship and law development, which often takes a Chinese and regional perspective, and he looks at central bank digital currency, the Belt and Road Initiative, and the US-China relationship. He's a recipient of major grants and awards and has advised or spoken at events organised by international organisations and institutions such as APEC, the Bank of International Settlements, UNCITRAL, the World Trade Organization, and the private sector. So you can see we've assembled a strong team of thinkers to provide you with answers to some of the questions which I am sure you have over the issue of these sanctions. So I'll start off by asking the participants, what are the major effects of the sanctions for business? And I will address Heng, Wei-Wan and Jono. So Heng, what do you see as the major effects of the sanctions for business?
Yeah, thank you, Deborah. I think this has been a very profound implication for businesses. That sanctions are unprecedented. So you have not seen those kind of sanctions, in the past. So in terms of scale and the countries that join those actions, and they are unimaginable. So the unimaginable is coming. And second, I think it's been involving a wide variety of industries. Thinking about small and medium enterprises, supporting the or engaging with Russia's industry to multinational enterprises that involve from trade to transport industry and to credit cards, to insurance sector. That involves value chain. You're thinking of stage from production to finance to transport, and also they are interconnected because, for example, transport industry, they're financed by, for example, Western banks and so on and so forth. So these are profound effects. And the third one, I think that's there are short-term and mid-term, but also long-term effects. Short-term and medium terms are definitely, involving that cross-border, flow of goods, services, even people, and also the, payments. And you're like to see, for example, sanction clauses, for example, that may pop up in the future contracts. In terms of long-term effects, you have the issue. I think one crucial one is how that will affect business assumptions, because these are things, as I mentioned before, the sanctions will be unprecedented, and many investors are risk averse and maybe increasing so, and they may do more than required. What we call the self-sanction, and also that will lead to, for example, network effects, because that will matter for trade blocks. And also they may lead to fragmentation, in the international international transactions. And another example will be that, that we have a lot of discussion about fossil energy sources, which are non-renewable. Down the track, whether, for example, renewable energy will develop, at a faster pace down the track. So there's a lot of things, which are involving not only about transactions, but about energy, security, and development infrastructure like payment infrastructure and so on and so forth. So they have a spillover effects. People, a country involved in the region may be also affected to some extent due to the concern over secondary sanction, and they have intended effects but also unintended effects. Which is the last point I want to say, that, for example, they have impacts on dollar and euro, although they will remain to be a major currency, but there could be efforts to de-dollarize trade. And also some trade may no longer be dollar denominated. Overall, I would see that landscape of trade, investment, finance, also involving dispute settlement, is likely to be quite different than before, and that has long-term implications. And I'm sure that other colleagues will talk more about other issues as well. Thank you.
Thank you, Heng. So Wei-Wan, what do you have to say about that basic question? What are the major effects of the sanctions for business?
Thanks, Deb. I think Heng has set out a very broad picture for us and touching upon different aspects of the impacts. So I agree with him. I think the implications and impacts are still unfolding, but are potentially significant, widespread, and far-reaching. So let me focus on trade-related sanctions and reflect on the implications, not only for businesses, but more broadly for the world trading system. As Deb mentioned, the trade-related sanctions have mainly taken the form of import-export restrictions, the suspension of the so-called most favored nation treatment, which allows the application of higher tariffs, for example. These sanctions have involved import restrictions on iron and steel products, certain luxury goods, agricultural products, raw materials from Russia, export restrictions on certain technologies and equipment, restrictions on the provision of services such as financial, transportation, telecommunication, mining, and exploration services. Now, Australia's major trade-related sanctions have included export restrictions of certain aluminum-related raw materials, import restrictions of certain goods relating to oil, petroleum, coal, gas, under Australia's autonomous sanctions legislation, and export restrictions of certain luxury goods to Russia, such as wine, luxury vehicles, parts, tobacco, etc. And then most recently, the suspension of most favored nation tariff treatment, applying an additional tariff of 35% to all imports from Russia, Belarus, effective from 25th of April, if I'm correct on the memory. So now, as mentioned, I think the impacts on businesses are still unfolding and require continuous monitoring. However, what's clear is that businesses around the globe will face mounting uncertainties associated with the war, the sanctions, and similar developments in other areas of trade policy, on which I will come back to it later. Beyond the impacts or potential impacts on businesses, there are broader implications for the world trading system. The current world trading system is primarily based on the rules and institutions established by the World Trade Organization, the WTO. For decades, this system has played an essential role in constraining trade restrictive and distortive policies and instruments and resolving trade disputes so as to facilitate trade worldwide and provide predictability and certainties for businesses that operate internationally. At the same time, this system recognizes the right of member governments to pursue trade unrelated values and interests, such as protecting the environment and national security. Now, a major consequence of a diminishing role of the system, in parallel with the rise of unilateralism, is that such rights may be abused, leading to tit-for-tat actions among governments. And consequently, businesses may face more trade barriers and unpredictable changes in domestic policies and regulations in overseas markets. I'll stop there as my general comments.
Thanks, Wei Wan, and thank you to the two of you for sticking to time. So, Jono, what do you have in mind for us on this question?
Well, thanks, Deb, and I think it's largely being covered by Heng and Wei Wan, but approaching it from the perspective of business in particular, broadly speaking, businesses that are operating in Russia, transacting with Russian banks, or more generally making payments in rubles, businesses that are exporting to Russia, businesses that are engaged with Russian individuals or firms, and businesses that are holding Russian-linked assets, all those businesses are going to have to consider the way that various sanctions regimes interact with their activities. So questions like whether they can perform contractual obligations they may have undertaken, whether they can make planned payments, whether they can go ahead with planned investments, or whether they might have to freeze Russian-linked assets currently under their ownership or control. One additional challenge for business that I'd like to highlight, and this is specific to businesses with operations or assets in Russia, is the possibility of retaliation, or you might say counter-sanctions by Russia for firms complying with sanctions imposed elsewhere. So I'm thinking in particular here of threats of expropriation by Russia against firms currently present or operating within Russia that might be seeking to shut down or to attempt to divest from their Russian operations.
Thank you. Well, we've heard the general views on all of that. So I'd like to turn to Jackie now. And Jackie, how does Australia's sanctions framework differ from other major jurisdictions, and what does this mean for business? I've got several questions for you, but you might turn your attention to that one first.
Thank you. And can I just say thank you for inviting me to participate in the panel today. It's such a topical issue, so very pleased to be able to contribute to the discussion. I think just hearing the other panellists sort of describe thematically some of the implications that have come out of the recent sanctions laws changes that we've seen. I think I had really, I guess, a couple of reflections to share which pick up on really some of the issues around uncertainty that has been created with the vast rate and scale of change that has come into play with these latest changes. And this is really where I've seen, I guess, some differences emerge with the regulatory settings we have here in Australia around trade sanctions compared to the regulatory frameworks that exist in some of the other major international jurisdictions, such as the US and the UK and the EU. And so I just wanted to call out, I guess, some of those observations, because I think as businesses face into ongoing uncertainty in not only the short, but likely the medium term, I think there's some points here that it's worthy for us here in Australia to be thinking about. So one of the changes that I've observed has been a distinction between, I guess, the range of mechanisms that our sanctions laws allows as new sanctions are rolled out. Our system here is fairly binary. It allows for the government to introduce new prohibitions. We've seen, as the other panelists have described, the type of prohibitions that have been rolled out, the type of new restrictions that have come in. But it's fairly an on-off process. There is a process to allow for sanctions permits and authorisations. They're very much a case-by-case application process, fairly tight conditions around national interest and other sort of specific criteria that need to be met to allow for it. So that it's not a particularly flexible system. That's sort of in the nature of these types of restrictions. But I compare that to some of the ways in which we've seen jurisdictions like the US and the UK roll out change. And their systems allow for concepts like a general licence, where there are restrictions in place, but there's an understanding that those restrictions are causing and will cause change and require business and individuals to adjust their dealings and what they are planning to do. And so they allow for some, in some cases, a wind down period around particular transactions and allow an exit and a winding out of relationships. So that's one area where we've certainly seen a bit of a change in the settings and a difference in, I guess, how much flexibility sanctions regimes sort of allow and permit as there are these changes. The second area where I've seen change is, I guess, just the extent of guidance that regulators are publishing and putting out. Historically in Australia, we haven't seen a lot of regulatory guidance. We have some guidance from the Australian Sanctions Office on their website. There are some outreach programs, but we haven't had, a particularly active prosecution or enforcement of our Australian trade sanctions laws. And I compare that to what we see from other overseas sanctions regulators, where there is a history and a practice of publishing guidance and FAQs, really with a view to helping provide a level of guidance and assistance to entities, individuals, businesses as they navigate changes. And again, I think there's potentially some learnings for us here in Australia around where we are going to see regulatory regimes implementing significant change quickly. We need to be cognizant that people, businesses want and need to comply with those changes, and if we can allow for systems and for guidance and mechanisms to help people do that, I think that really adds a positive dimension to the regulatory framework.
Thanks, Jackie. Now to continue on, to build on what you've already said, what steps do you see businesses taking to monitor compliance with these economic sanctions?
It's a really good question. I think that's the million-dollar question that businesses are asking as in light of these changes. And I think the answer really comes down to whether or not an organisation has in place a strong, robust compliance program. It's really difficult with the rate of change that we see new sanctions coming. In those early weeks, we were seeing new sanctions coming almost daily. So really the key and the answer to effectively ensuring compliance, monitoring compliance with these changes, is making sure that there's a really robust compliance program in place for an organisation. We generally see that organised around a number of key areas. It all starts with a robust risk assessment and making sure that a business has a really good understanding for itself of its areas of exposure and potential risk and what it needs therefore to focus on in its compliance program. And I think Jonathan mentioned earlier, there's such a diverse, wide range of sanctions that have been put in place. There was some descriptions earlier also about the types of trade restrictions that are in place. So that's going to mean that these sanctions affect different businesses in very different ways. A bank will have a really different risk profile to a company that generates revenue from business in different jurisdictions offshore. A very different risk profile to an Australian company that has a globally exposed supply chain. So all of those nuances really need to be fed into a company's understanding of its own risk profile around sanctions. I think building on that, communication and training are really key, making sure there's good awareness around sanctions, changing sanctions within a business. Making sure that senior leaders have made clear their commitment to compliance with the law and changes in the law, and that takes effect not only in sort of words and messages from senior levels of management, but also in making sure that there's the right resourcing to allow a business to comply, to do due diligence that takes time. And also a commitment to having to walk away or adjust the way you're doing business if that's what sanctions require. We see business investing a lot in due diligence and screening, and that's absolutely spot on. Obviously, understanding country risk, counterparty risk, and making sure that you're really able to look through and understand beneficial ownership. They're all important things to be doing to effectively respond to these sanctions. Making sure that contracts and transactions allow flexibility to deal with changes with sanctions and to ensure compliance is really key. So companies that have got provisions in their contracts which allow them to suspend or terminate or decline payment if it's going to put them in breach of sanctions laws, they are better suited and better positioned certainly to respond to changes, and we've seen that. And then finally, I guess wrapping around that, really some pretty robust evaluation and monitoring processes, because what we've seen is you can check the sanctions position on one day, but within a month it may have changed. So just really being mindful that things are not static and things need to change and be adjusted and continually revisited is kind of key to build into the compliance program as well. So there's a lot in there, Deb, but there's certainly some of, in our discussions with clients and with business, they're the types of things that we've certainly seen businesses look to make sure that they can point to internally to help them make sure that they're able to comply effectively with sanctions and with changing sanctions.
So I guess that you've added in there the good practice learnings for businesses as they navigate changing economic sanctions, which was going to be my next question. So thank you for that comprehensive answer. I guess we switch now to the implications of the sanctions on Russia itself. So I think I'll address this first to Wei Wan. What's your view about the implications of the sanctions on Russia?
Thanks, Deb. I think Jackie has covered lots of these issues very well and clearly. Her emphasis on the uncertainties that the businesses are facing are quite resonating with me. I think that's also the key term I would actually reiterate throughout the talk. But in terms of this question about the more specific implications for businesses and also the implications, from my talk about the broader implications for the world trading system and also the perhaps domino effects that might actually have coming out from the sanctions. I'll just get into most of its points. First of all, in terms of economic impacts, the World Bank recently issued a report to show the negative impacts of the war on the global economy as a whole and the impacts of the economic sanctions, not only on Russia, but also on other economies. These have included, some of the panelists have also mentioned sharp price increases in certain commodities, such as natural gas, coal, crude oil, wheat, aluminum, iron ore, potential shortage of supply of certain agricultural goods and inputs, very importantly, such as grain and fertilizers. Again, I think it is still too early for us to fully understand the impacts of the war and the sanctions. But again, to reiterate, we are facing lots of uncertainties on how this war and the sanctions may further evolve or even escalate. So from a business strategy perspective, I think firms will need to keep close eyes on how the war and sanctions may affect their industries, the related economic sectors and actors, their source of supply, production, and international sale. Now, I do want to mention that I think Australia's sanctions seem to be carefully contemplated to cover a relatively narrow group of goods and services, while still having some meaningful impact on Russia, I think. But sanctions adopted by other major economies may also have impact on Australian businesses that operate internationally. Now, the broader issue, very quickly, concerns the implications of the use of economic sanctions for the world trading system and international cooperation. The war-related sanctions may or may not be covered by the WTO rules. But when they are covered, the sanctioning countries have relied heavily on security exceptions, which allow deviation from WTO rules for the protection of security interests, such as in time of war and other emergency international relations. The Russian sanctions represent a unique case, built on a moral ground shared by all economies, I think. So it would be much easier to apply the security exceptions compared to other major cases. Now, however, there has been an ongoing trend or situation in which countries increasingly resort to unilateral actions or countermeasures, as Jonathan also mentioned, for security and other reasons. Now, this rise of unilateralism has become a major existential challenge faced by all economies today. So I'm going to stop there. I'm going to come back to elaborate on the examples or the implications later on.
Wei Wan, I was going to ask you if you might give us some examples and explain their implications now when talking about the growing abuse of national security and recent regulatory development, for example, in the EU with anti-coercion. Now you're on mute, Wei Wan.
Yeah, so sorry, I muted you back. Thanks for the opportunity. So I hope I won't take too much time, but just let me give you several examples. There actually have been many recent examples which show that the risk is not insignificant or unreal. I'm talking about the broader implications. Now, for example, I guess this is well known. The starting from 2018, the U.S. steel and aluminum tariffs on trading partners and allies. The U.S.-China trade war followed and involved rounds of tariffs imposed by both sides. And then we also have seen, the ongoing economic tensions between Australia and China. But more recently, the EU has been contemplating an anti-economic coercion mechanism, seeking to target any foreign actions that interfere with EU or a member state's legitimate sovereign choices and affect trade or investment against the EU or member states. So that's another recent example. Now, China has rolled out a series of new laws and regulations to establish a comprehensive framework for the protection of national security. This regulatory effort began with the enactment of a new national security law back in 2015. But most recently, since 2020, China issued 4 major laws and regulations in a very short period of time, including, the measures targeting, unreliable entity lists, export control law, rules on counteracting unjustified extraterritorial application of foreign legislation, and more recently, the anti-foreign sanctions law. Now, in all these measures, economic security has become an embedded element of national security. They have also instituted a mechanism to authorize the use of a broad range of countermeasures against foreign actions that adversely affect China's economic security. Now, whether these actions are actually in conflict with WTO rules requires a detailed assessment based on evidence. However, they demonstrate, in my view, a trend of major economies self-judging on matters relating to economic coercion, foreign sanctions, national security, and possible countermeasures, and at the same time sidestepping the WTO. As mentioned, this would create mounting uncertainties and challenges for businesses. Now, final point, the actual impacts on businesses are not necessarily all negative. The impacts depend on many factors, such as the types of trade policy instruments employed, their magnitude, coverage, and duration, the countries involved, the industries and goods services affected, whether others retaliate. Trade tensions between two countries are most likely to reduce their bilateral trade, affecting their own industries and businesses, especially those relying on foreign inputs for production, as well as consumers. However, a bilateral trade tension may also create opportunities for certain industries and businesses to diversify sources of imports and destinations of exports, leading to increased trade with other countries. So in other words, although trade tensions such as the US-China trade war as an example, are typically detrimental to the overall national welfare of both economies, the impacts on businesses may vary. What's certain is the uncertainties in domestic and global markets resulting from such tensions, and also the rise of unilateralism, which will remain a major challenge for businesses. Thanks, Dave.
Okay, thanks, Wei-Wan. So let's turn to Heng. Heng, in your view, will there be a move from globalization to localization given economic sanctions? And what's the likely impact of this on global value chains?
Thank you, Deb. I think this is a really different world or economic system we're looking to, because we can look at it to two perspectives. One is that you can look at the effects of the sanctions. The sanctions basically disconnecting Russian banks, largest banks from the international financial payment infrastructure, and the sanctions targeting on trade and the possible related issue regarding secondary sanctions, and also they also involve issue like besides secondary sanction, you also have the issue about self-sanction. Businesses may thinking about what the response from the consumers or regulators from another jurisdiction. So they may think of going probably more than what is required. So that will need to kind of move away from globalization, because you are not able to connect as before. On the other hand, I think that's actually Jonathan and other panelists also mentioned about the counter sanctions, the measures taken by Russia and other countries. By Russia, that also push towards a direction away from globalization. So it means that both the sanctions itself and the counter sanction are largely driven to one direction, that is move away from globalization and to localization. Thinking about countries moving back their global value chain, to their home country, to Asia and elsewhere. So that's a pretty, I think, a strong signal. I think that's also probably will go beyond the sanction period, because it's much easier to, it's much difficult to reconnect. If you move out something, you think about sunk cost, and so on and so forth, and that have a long-term impact. And also, I think that's also have another issue about the globalization, localization, I think, and also global value chain. It's also about infrastructure, so we're not only talking about trade and investment, but also talking about underlying, international systems, thinking SWIFT, and others are a typical example. And there you're like to see that, they will have a long-term implication. And also on this point, I want to say that even if they have other long-SWIFT system, they also work towards a different scenario, because for long-SWIFT system, they are largely used for transactions denominated in currencies other than dollar. So they are not really used for the currency of dollar-based one. So we'd like to see that includes the value chain design and so on and so forth. So I think that's there profound changes that will happen down the track. Thank you.
Okay, thanks. But we might continue with you, Heng. Will cryptocurrency and central bank digital currency be used to bypass these economic sanctions?
Thank you, Deb. I think this is a great question because it links to, we're talking about businesses, but also we cannot forget the government's, the public role in that regard. So that involves like regulation. So you mentioned about crypto assets. That's a typical example where in theory or the crypto assets can be used can be anonymous. Depends on the context, depends on how strongly the regulation would like to be. So for example, it's like to see that particularly regarding smaller exchanges or other platforms dealing with sales and purchasing of the crypto assets will enforce know your customers rules. So on one hand, crypto assets might be used in those contexts to counter or to avoid the sanctions because they are not subject to the same or very strict rules in particular for smaller ones compared with banks. But on the other hand, I would like to see that actually there also is a limit on the scale of the use of crypto assets. Because if you look into traditional or pre-existing transactions, a huge volume of that, and to make that happen, by a different way, like crypto assets, will be quite different. Because one thing you see that the pricing of crypto assets, changes dramatically, and also you have a lot of barriers that you have to go through. And also don't forget also the intelligence or monitoring of the crypto assets, by regulators. And also on the other hand, they also have a call for strengthened regulation of crypto assets, so they basically, I think they're moving targets, how they operate in practice, how the regulators nationally and internationally are working in that regard. And secondly, when you're talking about, for example, the digital public money, I think there's a more involving issue of data, whether you're able to, have, ready to share data, because digital currency, for example, involving data, and they also involve issue about infrastructure. Is there infrastructure already put in place? Can they interoperate whether one party trusts another party to use those kind of the digital currency? So these are a lot of questions, and that go beyond that. And also that involve a more broader issue like cybersecurity, the involving issue about trust, the involving issue about the technological uncertainties and so on and so forth. So I think that's is possible, but they also have a lot of opening questions, and that will change over time.
So Heng, you've differentiated, of course, between cryptocurrency and central bank digital currency, but central bank digital currency seems to be rising fairly quickly, quicker than some people thought it might. And it seems that it might be used to bypass economic sanctions. I understand you've discussed that briefly, but might you like to expand on that a little, because we are going very well. Everyone is stuck to time to date, and we have a bit more time now. It might be interesting for the listeners if you could expand on that a little more.
Yeah, and thank you, Deb, for providing me the opportunity to explain a little bit further about the central bank digital currency. We know that central bank digital currency is digital version of the national currency, and the difference is that it's from cryptocurrency, which are led by private entities, and central bank digital currency (CBDC) is issued by central banks. So you see that's but we see a similar scenario is that you have to think about the issue about whether the users have confidence or trust in central bank digital currency, because it's still be a currency. Whether the parties would like to choose that, and also you also have to think about the issue of how the different parties are happy of deal with that. Because on one hand, you have the issue that whether one party want to use a certain CBDC, central bank digital currency. Another side is that whether the other party also wants to use that. So that relates to the issue about, it's not only about the format of the money, whether it's digital or traditional paper currency, and it's more about whether you have trust or confidence in that, and whether the money can be convertible, easily, because you are thinking of offset your risks. You have the money and then you want to use that. And secondly, you have the issue about, besides the trust or confidence in the currency, you also have geo-economic factors, because they may have efforts to counter sanctions, But that end of day depends what are the other parties' preference, whether they want to go this track or not. And also that depends about economic consideration and geopolitical and geoeconomic considerations. And also another issue I want to see that technically speaking, those have a lot of complexity because, you know, you're talking about not about have a cash, you know, I use that overseas. It's about infrastructure, you know, digital currency involving how do you receive that with the technology, you have the, you know, infrastructure to deal with that. That won't happen overnight. And also a lot of complexity, as I mentioned before, like besides technology uncertainties, whether they're stable, whether they are stand with cyber attack, also about data, you know, whether you're comfortable to, you know, exchange data, whether people are concerned about privacy protection and so on and so forth. Yeah. So I think this is a pretty early stage, you know, for international use of the CBDC, and they'll have a lot of roadblocks, you know, and any setback in those area will have a huge blow of central digital currency because people may be concerned about its use.
Oh, thank you very much, Heng. So just back to Wei Wan before I move on to Jono and Jackie again. Wei Wan, what do you think that what role will the WTO play in dealing with the rise of unilateralism that you spoke about earlier?
Thanks, Deb, for switching back to me on this question. Now, just very briefly, because this is really potentially a big topic, I'm just trying to capture some of the most, I think, important aspects to enhance, you know, business understanding. So first, I think the WTO is a member-driven organization. This means that whether and how the WTO may play a positive role in bringing governments back to cooperation, in resolving the challenges we're facing today, will depend on the internal politics and political will in each member state. Now, here I'm not referring to the Russian sanctions itself. I'm referring to the broader, you know, implications for the rise of for the world economy, especially associated with the rise of unilateralism. Now, in terms of the specific roles that the WTO can play, we're looking at the two major functions of the WTO, negotiations and dispute settlement. The WTO has long provided for informed negotiations or deliberation on how to address emerging issues and resolve disagreements on trade-related matters. Now, of course, the WTO is not the only forum, and governments can also resort to bilateral or plurilateral platforms. Nevertheless, WTO negotiations remain an important forum for such purposes, and the governments do continue to resort to the WTO for further liberalization of trade, development of trade rules, resolution of trade disputes. Now, the WTO's dispute settlement system, even if it is not fully functional at the moment, remains the only international mechanism for settling trade disputes. Now, this again may not necessarily apply to the Russian sanctions, but when we talk about, you know, anti-coercion instruments, when we talk about, you know, national security-based regulations, the WTO may actually play a role, either negotiations or dispute settlement. Now, at the very least, I think the dispute settlement system provides a transparent and rules-based process for litigation, and also importantly, opportunities for governments to resolve the disputes in the process by themselves, including via consultations. One of the problems is that the WTO process, either negotiation or dispute settlement, takes too long. Therefore, I think one problem for the government, or one question for the government, is that whether governments can find a way to make the process more efficient, so that, you know, to make the system to be more effective and attractive. Now, finally, I think this is really just kind of a more general comments, which concludes my answers on this question. I think the government must start reflecting on the part of the history which shows unequivocally how unilateralism can be mutually destructive and how cooperation can rebuild peace and prosperity. I hope the current trend of practices based on unilateralism and confrontation may otherwise generate the political will in each member state to reverse this trend. And I think this such political will in turn must be based on efforts of all stakeholders, including businesses within and outside an individual economy. I'll stop there.
Okay, thanks, thanks Wei Wan for that. We'll pivot again, to use an overused word, and we'll now focus on Jonathan, who I would like to ask, speaking generally, what are the prospects of sanctioned Russian individuals or entities bringing ISDS claims against other Western states?
Thanks, Deb. It's a good question and an interesting one. And to make this sort of scenario more concrete, we might imagine a situation like the Nord Stream 2 gas pipeline, which many of you may have read about in the press. This is a pipeline that's been built to deliver Russian gas to Germany. And in response to Russia's invasion of Ukraine, Germany suspended the certification process that was necessary for the pipeline to go into operation. So currently, as a sanctions measure, the ability of that pipeline to go into operation is temporarily suspended. And cases like that sort of help crystallize this idea that Russian investors might then be looking at their legal options to try and bring claims against Germany in this case, either seeking compensation or revocation of the sanctioning measure. And the investment treaty regime, so the ability for foreign investors to frame claims against states and then bring them directly to international tribunals in the form of international arbitration, provides an opportunity for this. And the first sort of issue with cases like these is whether there is a relevant investment treaty, because unlike the World Trade Organization, which Wei Wan has been speaking to in particular, which is a multilateral system, investment treaties are bilateral or plurilateral instruments. But in this case, the owner of Nord Stream 2 is, formally speaking, a Swiss company, Nord Stream 2 AG. That Swiss company is wholly owned by Gazprom, the Russian company, which is why Nord Stream 2 has been sanctioned. But as a formerly Swiss entity, it's likely that Nord Stream 2 would fall within the coverage of the Energy Charter Treaty, and that would bring about the possibility of that company, which is wholly Russian-owned, bringing a claim against Germany. And once a jurisdiction in a case like that was established, there's a whole set of quite interesting and also technical legal questions that fall out underneath that, including whether suspension, temporary suspension, or perhaps even permanent suspension of the certification of a pipeline is a breach of the treaty's guarantees of investment protection, so guarantees like fair and equitable treatment. And if it is, whether there are any relevant exceptions or justifications that might excuse or justify Germany's sanctions in those particular contexts. So in Nord Stream 2, again, continuing with this example briefly, on a first pass, it looks like a decision, at least, to suspend a pipeline going into operation that was maintained over a long period of time could ordinarily be a breach of an investment treaty. So that looks like Nord Stream 2 has a kind of prima facie claim there. Although in this case, it seems likely that Germany would be able to bring that sanction under the security exception provision of that treaty. So that's, I guess, just one example of a wider possibility of claims by Russian associated individuals or entities. And the way those claims might potentially work out will depend to some extent on the specifics of the treaty in question, because they're not all identical.
Thanks, Jonathan. And just to reverse that question, what are the prospects of ISDS claims by non-Russian entities that are penalised for dealing with sanctioned Russian entities?
So this is also a very interesting possibility and a challenging one. It's a much more hypothetical scenario we're dealing with, at least at this point. So we're thinking about a situation, say, if a hypothetical Australian firm operating in Europe or US that has some sort of engagement in Russia were penalised by, let's say, a European government on account of breaching that sanction regime. That penalty led to significant loss on behalf of the business, perhaps the loss of an entire investment, and the firm then sought to frame a claim against the government that was applying the penalty based on breach of the sanctioning measures, to frame that up as an investment treaty claim in the same sort of way that I described with the possible claim arising from the Nord Stream 2 scenario. And so, you know, we'd be working through the same steps of analysis. Is there a relevant treaty? What's its jurisdictional coverage? Does the penalty in fact breach the substantive guarantees of the treaty, and are there relevant exceptions or justifications that might apply? And just in relation to that final point, I think one really important issue here in international law, this goes to the question of justifications that a state imposing sanctions might invoke by way of a defence to a claim under an investment treaty, is this argument of countermeasures. So in international law, in public international law, which is the system of law primarily between states and includes the law of treaties, countermeasures are a form of retaliation that is available. So the idea is that when a state breaches international law, here that would be Russia that's breached international law by invading Ukraine, another state can be justified in taking retaliatory measures that would otherwise be in breach of international law against the responsible state, so against Russia here, but subject to a range of very strict conditions. So this countermeasures justification would be something that's quite relevant in these sorts of cases, and indeed to a wider range of international law issues arising in relation to sanctions.
Thanks, Jono. Jackie, I don't know if you've got any comments on any of those points that have been made by my colleagues. We haven't heard a lot from you, unfortunately. I haven't addressed a lot of questions to you, so there may be something in that last bundle that you'd like to comment on before we get to our last question and ask you a more general question.
Look, thank you. I think one of the fantastic things about panels like this is just bringing together lots of different perspectives, and I've been fascinated by hearing just about some of the areas of expertise that our other panelists have spoken to. I think one of the things that has really struck me as just a real central challenge in this sanction space, and the word unilateralism has been used a lot. That's been a strong theme that's come through. I just hearing that and sort of seeing the way in which the sanctions changes have played out in the last few months, the other word that comes to mind is just complexity. It's not just uncertainty that's arisen for business and for governments, but it's just the sheer complexity of what that has meant in terms of the legal landscape. And, you know, we've heard from some of the panelists about that, you know, that may give rise to a range of options at WTO or investor state sort of claims, but gosh, that's a complex landscape for business to navigate. And it just, some of that may be very well absolutely the intention of what has happened and the intention of the decisions that each government has taken about which sanctions it wants to impose and which it doesn't. We have at the same time heard a number of jurisdictions talk about staying in step with each other. And certainly that's been the Australian government's message around its decisions on sanctions, is that it is moving, although it is doing it using its autonomous sanctions framework, it is doing it with the intention of keeping in step with international counterparts. So for me, I don't have an answer to that, but just hearing this discussion and just reflecting on the last few months, I do think there's scope for, even if we are in a world where there's unilateralism and governments are making their own decisions about what these regimes look like, I do think that there is still scope for us to, and for our governments to be thinking about the implications for business and the sheer complexity of businesses which still operate in a global environment, to try and reduce that. We've certainly seen some examples of that. I think about the wave of sanctions that came in place with the annexation of Crimea, and Australia followed some new sanctions that were first put in place in places like the EU, and there was a lag and an opportunity for sort of draft legislation and consultation and discussion, and a move to try and better streamline what Australia put in place to align with restrictions elsewhere. And I think there's potentially a lesson there around, yes, nation states might actually unilaterally and do things independently, but where they're seeking the same policy objectives, at least from a business perspective, trying to do that in a way where those national laws work together and there is less complexity rather than more, I think is something to aspire to. That might be a somewhat optimistic view, but certainly something I think worthy of consideration. If the policy intent behind a lot of what is happening is united, then hopefully it can be implemented in a way which sees more alignment rather than less.
And thanks for that, Jackie. And you've once again taken a practical and a practical approach to the issue as a practitioner, but you can see that dealing with all of this must be a nightmare for a global corporation, and a little more cooperation or collaboration may well make life easier for businesses who operate globally. Look, I've just got one more question for each of the panel before we turn to questions from the audience. And I would like to just ask a general question, which is, looking into the future, is there any issue that deserves attention regarding economic sanctions, and how should that issue be addressed to benefit business? So let's go to Heng on that.
And thank you, Deb. I think these are numerous issues that deserve attention, and I would like to cover just some of them. So one thing I'm thinking about the role of the technology. So what is the role of technology may play in the sanctions? Because you see that actually in the anti-sanctions or counter-sanctions, the technology will play its role, including people thinking about geofencing, or people thinking of using the high technology to monitor what happened, and so on and so forth. So it's quite interesting to see how businesses and regulators, use technology and to what extent, and for what purpose, and whether the implication will be. And the second thing I think I'll be interested in, is about the development of the energy. Because we know that fossil energy sources are non-renewable. So basically, how would be the sanction affect the sustainable development? Because countries may speed up their shift away from fossil energy. How they'll play in the long term. And also, I'd like to see that the issue about third one, I think, is how long the sanctions will exist. Because businesses' assumptions, I think, has been challenged, and they may outlast the sanction itself. And I think that makes sense for us to have a forward-looking thinking, to think about long-term costs and benefits, to think about unimaginable and what will happen in the next 10 years and longer for businesses. Thank you. Sorry, Deb, I think you are on mute.
Sorry, you would think we would have gotten used to this by now, but no. Wei Wan, what about you? What do you have to say on that question? Looking into the future, is there any issue that deserves attention regarding economic sanctions, and how should it be addressed to benefit business?
Thanks, Deb. I think lots of things have already been amply discussed just now. I think my first reflection on what we have said as a panel, and particularly from what I have said, is that I think this particular sanction against Russia is quite a unique case, but it creates a window for us to look at, the issue more broadly in terms of, what I said about unilateralism, in terms of the uncertainties and complexities, as Jackie said, in front of businesses, but also in front of governments. So we need to have kind of a broader perspective into the future problems, going beyond the Russian sanctions to look at some other regulatory developments and also, independent or unilateral actions taken by all governments, major economies in the world. So now, how to deal with that challenge? I think we need to look at, from the individual perspective and also from a collective perspective. From individual or a micro perspective is from how business could actually deal with the challenges by themselves. I mean, that's a necessary step as part of the strategy to deal with the future challenges. So that will include, as I said, the business needs to do, and also Jackie mentioned about the due diligence in individual transactions, but maybe you need someone, experts in your team, to actually keep a close eye on all of the recent and future regulatory developments and the implications on your business. So I think that's from the individual perspective, but also about cooperation, right? So when you face the challenges, but you may also have opportunities to collaborate with different partners as you used to. Now, at a collective level, I think it's important for businesses collectively to channel their interests into policymaking at the government level. And again, how governments collectively would be able to address the challenges at the government level through cooperation is another thing I want to mention. Now, there are many channels of cooperation or many ways of cooperation, and there are many platforms, as I said, and the journal also mentioned about, bilateral level, plurilateral level, multilateral level. So that's another thing I think we need to be thinking about. And obviously, the policymaking will rely a lot on business efforts and as well as the efforts from other stakeholders.
Thank you, Wei Wan. What about Jonathan?
Yeah, sure. So the question was, are there any issues looking to the future that deserve attention? Well, there's a lot. I'll pick out two very briefly. So the first one picks up Jackie's point about complexity, and for me specifically, the complexity that arises from potentially overlapping sanctions regimes. So the idea that the application of the Australian sanctions regime to Australian entities operating outside Australia would overlap with potentially with the sanctions regime of the territorial jurisdiction. It's an issue that is interesting. I think it deserves attention. How should it be addressed? One thing I think would be interesting, at least from my perspective, and here I'm going to sound like an academic, but those of us who've worked in practice and also academia understand the challenges of complexity. But one of the things that can be really helpful is to understand more about specific situations in which practical tensions arise, because the concerns around confidentiality in business mean that often some of these complexities are discussed in general terms, but for those of us who work in these fields in policymaking and academia, it can be helpful to grasp what specifically might be at stake, or the for example, the contradictory or largely incompatible demands that overlapping regimes might place on businesses in relatively clearly crystallized circumstances. So that can help I guess that precision can help clarify some of the policy and legal stakes in play in questions of complexity. So I think that's one important step to addressing some of these challenges. Another issue that I think deserves attention, I'll mention very briefly, is how the sanctions regime interacts with international dispute settlement, and particularly the ability to enforce arbitral awards or judgments against frozen foreign assets of Russian or Russian-linked entities. So that I think is also an interesting and important question that deserves attention.
Thank you. And Jackie, do you have anything that you would like to add to this? Looking to the future, is there any issue that deserves attention? I mean, I think that's a very, very, what could I say, a very, very limited question given the number of issues that have been raised. But if you could, if you'd like to just focus on one or two, that would be great.
I like the question because it's kind of a free question, isn't it? What's on my wish list? Yeah. I think one of the things that I think is worthy of attention in Australia in particular is recognising that our sanctions regime has materially changed in the last few months, and we need to make sure that as a country we've got the right resourcing that wraps around an area of law that is now much more heavily regulated and having a much greater impact on business and the community than previously. And so I think what for me would I like to see the Australian government pay more attention to is really just making sure that there's the right level of investment in the regulator that is charged with administering and enforcing these laws. You know, we have at the moment the Australian Sanctions Office within DFAT. You know, they have rebranded and lifted what they do in the profiling well before this latest wave. But this is an area of law which is actively impacting on business, and I think that calls for a corresponding level of investment in the capability of the part of government that is charged with administering it. We're in a world where indicative assessments and applications for permits may be required with increasing frequency, and we need to make sure that we've got the right settings to support individuals and business maintain compliance with the law as we continue to see things change. So that would be my wish list in terms of things that people pay attention to going forward. Certainly something I would be interested to see attention being paid to.
And that just shows the broad range of issues which are arising from these sanctions that need to be considered and addressed going forward, just having been raised by our panellists. So I thank the panellists at the moment, and now we'll turn to questions which have been raised by our audience. And I have a question which is, given the US president's proposal to sell off assets of Russian oligarchs and other economic measures, what are the impacts on due process of law versus the exercise of police power extraterritorially? And I will focus on Jono for this one.
Thanks, Deb, and that's a really great question. It's definitely been getting some airtime in the news lately. I guess I begin just by clarifying that I'm not sure I see this as a question of extraterritoriality necessarily, because we're talking about the US exercising powers of seizure in relation to assets that are territorially within the US, so in US jurisdiction. And a couple of other, I guess, important framing distinctions here. So the first one is between the freezing of assets and the question that you've asked, which relates to a case of seizing the assets and selling them off, presumably, at least in the sort of ideas that have been floated in thought bubbles in the US, as a way of funding Ukrainian recovery. So the freezing of assets is obviously something both in the US, here in Australia, under international law that I think everyone is very comfortable with, whereas seizure and sale of Russian assets is clearly what's being discussed here is something that's much more controversial. And there's an important distinction as well between Russian state assets and oligarch assets. And I think the seizure of oligarch assets in particular is going to be more legally problematic, both under US law and international law, especially absent a very, very clear connection between those assets and the Russian state. But to turn now quickly then to the substance of the question, does this raise due process concerns? Is it consistent with international law? I'm more comfortable with this than other commentators. I think if there were clear legislative authorization in the US, that would go quite a long way to addressing due process concerns, particularly as a matter of US law, but also as a matter of international law. I think there is a basis under international law for seizure and sale of Russian state assets, provided that funding is used specifically in the form of reparations for Ukraine to support Ukrainian recovery. That legal basis is this idea of countermeasures that I've referred to earlier. I mean, it's not a clear-cut issue, and perhaps you asked the question because you're familiar with some of the debate around this. But I think it is something that could be done if it's done carefully.
Okay, thanks, Jono. We've got a question here. What is the effect of cryptocurrency on avoiding economic sanctions? Since cryptocurrency is decentralized, regulation is quite tricky. Do you think it can be used to avoid sanctions going forward? For example, Russia embracing cryptocurrency to avoid sanctions imposed through private companies. And I'll refer that one to Heng. Heng, would you like to answer that?
Thank you, Deb. I think this is a very complicated question, because on one hand, cryptocurrency may be used, without showing the identity of people behind it, particularly in this context where if a smaller platform which has not really enforced a strict know your customer rule, so they theoretically can be used by people who you're not sure their background. Another hand, they also have uncertainties because the regulators also trying to understand, although they have limited resources, trying to understand what had happened, by the cryptocurrencies, trying to investigate, and they may also work with the private sector, because they may have sophisticated technology and more information than the government to identify, potential user or of those currencies. And secondly, is that in reality, you also have difficulty. How do you able to do that at a large scale? As mentioned before, because in the ordinary economy, using traditional currency, the stable value, you can use that at a large scale, but it's more difficult when you go to the cryptocurrency. And also they may, drive the price up, if you use the same scale. They're basically quite difficult in terms of feasibility, so you can hardly replace that. And thirdly, I would like to see that also have the efforts. You see that, where the domestic regulators try to strengthen their regulators to deal with those issues, and they call for international collaboration and so on and so forth. So I will see that there are a lot of uncertainties. It looks like to be a dynamics on both sides for the private sector and public sector, and it remains to be seen how the regulation may be imposed. For example, they may have a long-term implication for crypto assets industry. They may need to strengthen regulation, down the track. Thank you.
Thanks, Heng. I've got a question on about the invocation of the national security exception of the GATT 1994. Since essential security interest, as defined, is a self-judging subjective element of such exception, is it possible to involve national economic security in essential security interest, which is opposed by some scholars? So Wei Wan, one for you. And of course, if anyone else wants to add to these, please put your hands up, colleagues.
Thanks, Deb. I'll just trying to borrow what Jackie said earlier, this is a $1 million question. It's quite difficult. We have limited jurisprudence, but in both disputes, recent disputes that the WTO panels considered this issue, they rejected the claim that the security exceptions clause under Article 21 of the GATT is self-judging or non-justifiable. So they basically said it is subject to the scrutiny of the WTO tribunals based on certain conditions and legal tests. So that was what's said. Now, I think your question is more about whether the current security exception under Article 21 of the GATT has scope for consideration of economic interests. Now, here we draw a distinction between the traditional security interests and the ever-expanding, in my view, interests in relation to economic security. So we had a famous case in the 1970s that the protection of domestic production of goods can be an issue of national security, right? So if you take that path, then you could potentially argue lots of things can be national security. Now, just given the time I have, very quickly, I think the current jurisprudence under the WTO provides flexibility for considering security interests, especially those resulting from armed conflicts and diplomatic crises. But the uncertainties are basically what I said about whether it actually provides scope for consideration of the increasingly expanding security interests. And secondly, if security interests is included to some extent under the current exception, national security exceptions, whether the current legal tests needs to be adjusted to achieve a good balance. Remember, if everyone can just make an argument that this is my economic interests and that is my economic interests, then you will basically say, again, what we're saying, the self-judging, and then taking all different kinds of measures to protect such interests. So that will be something I would say to be avoided, either at the level of individual economies, but also at the WTO.
Thanks, Wei-Wan. Jackie, we've got one for you. Multinational enterprises operate at different levels and in different jurisdictions. What steps should business take to monitor compliance with economic sanctions, given their internal structure? For example, daughter companies, joint ventures, business areas, and jurisdictions.
It's a good question. I think maybe part of the answer to this question is actually within the question itself. I think it's really important, as the question I think alludes to, there's not one size fits all here around what businesses need to be doing to make sure that they're in compliance with sanctions. And for me, I guess the starting point is really, it comes back to that principle around risk assessment. Making sure that each business has for itself worked out, given its internal structure, given its JV relationships, its subsidiaries, the countries, the jurisdictions, the business areas it works in, what does it actually translate into in terms of potential sanctions risk and touch points? That's really the heart of, I guess, providing an answer into what does that mean and translate into in terms of steps that should be taken. So I'd say it really comes back to starting with a risk assessment, understanding the impacts for that business given its particular circumstance. The other piece I would say where I've seen huge value is having really capable people within a business who understand not only sanctions, but also understand their own business and who can bring together, I guess, that understanding what the business is doing and how that might impact on how sanctions may impact on their environment. So, I think we've in the last few months seen just amazing in-house legal colleagues, in-house compliance colleagues, really switched on people who've informed themselves about the changing sanctions landscape and being able to then work out for their businesses how that translates. I that this is not an area where external advisors, I think, are able to wave a magic wand and provide all the answers here. So certainly having adequate internal resources who have the time and space to think about the implications and to make sure that those appropriate risk assessments are undertaken. I've certainly seen that as being sort of key parts of how companies have successfully navigated those sorts of challenges.
Thanks, Jackie. And look, there's another question here for you, which to some extent overlaps with the last one, I think. It asks, could you please further explain how businesses should allocate the right resources to allow the business to conduct due diligence? Is there good practice in exploring the counterparty risks and beneficiary ownership and designing contracts with flexibility to deal with sanctions?
There's a lot in that question, or really, really good things to be thinking about. I think one, for me, the starting point in thinking around allocating resources, I often come back to what is the business trying to achieve? And from a legal perspective, the test is that companies will have a defence to a breach of sanctions laws if they can show that they exercise due diligence and reasonable precautions. So that's kind of the litmus test that we're wanting to come back to. And what that means is that it doesn't mean applying the same level of extensive resources to all situations, to low risk situations and higher risk situations. In fact, that's not reasonable precautions. That's sort of boiling the ocean and meaning there's, you're casting the net too wide and the real issues are going to get missed. So I think when businesses are faced with thinking, how do we allocate whatever resources we have in the right way, comes back to risk assessment, identifying higher areas of risk. I think it comes back to triaging and screening to spot issues early and to devote resources to those more complex issues, rather than potentially setting up processes which apply in an overly broad way. To give an example, if you're talking about payment screening, obviously things with an international touch point need to take greater prominence than things that are purely domestic. There are some simple things in the sanctions world where you can be using country risk and counterparty risk to be calling out and identifying where there may be areas of greater need. The other thing that I'd say is that there is huge value in actually having a more formalised, documented process where you can think about where are you going to devote resources, rather than a situation where an organisation responds ad hoc to issues as and when they arise. I think that can lead to a disproportionate level of attention being devoted to a particular issue just because it's come to prominence, rather than having a more formalised process for the business to spot when it needs to give attention and pay attention to sanctions risks. So hopefully there's a few helpful things in that.
Thank you. That was very useful, and we've got time probably for one more question, which I'll address to Jonathan. Would you please talk more about the countermeasure justification in the context of the investment regime? We've probably got 3 minutes, Jonathan.
Well, I'll try to be brief. So just as a general framing, recall that countermeasures is a justification under international law. So it's something a state could invoke as a justification for doing something that would otherwise breach international law by way of retaliation against another state's prior breach of international law. So to make it concrete here, Russia invaded Ukraine. That's a clear breach of international law. Is Germany entitled to suspend certification of a gas pipeline in a way that would otherwise breach its commitments under the Energy Charter Treaty as a retaliation against Russia's invasion against Ukraine? So is that justified as a countermeasure? And this is whether countermeasures are even available as a justification in investment treaties has been controversial, and it's been caught up in an argument in a couple of NAFTA cases involving Mexico. And the legal question here is about whether investment treaties should be conceived of as agreements between states or whether they are better understood as conferring rights directly on foreign investors. The implication of the view that the treaties confer rights directly on foreign investors, at least according to some tribunals, is that a state cannot be justified in taking a countermeasure because the countermeasure is a form of retaliation against another state, whereas if the investor is independently entitled to these rights, then there can be no countermeasure taken that affects the investor's independent rights. So in my view, countermeasures are available on the basis of the structure of the treaty, but that has been a question that's controversial in the past. And there is also a second issue which relates to the possibility of Germany invoking countermeasures as a justification when Germany is not an injured state. So basically, here Russia invaded Ukraine. Obviously, Ukraine can then take countermeasures against Russia under certain conditions, but can Germany take countermeasures against Russia? That's also controversial. My view is the answer is yes, but that is something just to flag coming out of your question. Thanks.
Well, thanks very much for that quick but expert analysis, Jonathan. Look, we've probably reached the end of our ability to answer questions and provide you with information. But as you will have noted, our speakers have raised a whole range of questions which deserve further consideration, and I thank them for that. I thank them for being highly skilled and well-informed speakers. I thank the Segal administrators who have set up this session and monitored everything so well. And I also would like to thank you, the audience, for your wholehearted participation in this important CBIL event. And I look forward to seeing and hearing from you at future seminars. So thank you all very much for your attendance and participation.